even know. You're Tasia 1 Mac?
Yes, ma'am.
Mr. Mack, we've had issues with you and your drug patch now. I can't even tell you how many times, countless number of times. You were here not that long ago. Hold on. You were here. I told you last time you were here that I didn't care what it took for you to have a testable patch on when you went back to have it tested. I got an email from Johnny's Auto dated last Thursday, the 25th, where it says you came in without a testable patch on, you claim it fell off, they put a new one on you, and they will update us. So you went in without a testable patch last week, is that right?
No, ma'am. I'm not even with Johnny's no more. I get my patch from Al Reed.
They test you, Al Reed tested you?
Yeah.
So you didn't go to Johnny's?
Oh,
When did you go to Al Reed?
Call Al Reed and call Johnny's too. Why would they send us an email that says, do you have a patch on right now? When did you get it?
Thursday? Friday?
Okay, from where?
Al Reed.
From his office?
Yes, ma'am.
Or he might, because Al probably uses Johnny's. Did you have a patch on when you went to see Al Reed last week?
Answer this. Al.
Answer yes or no. Are you, tell me the truth, because we're going to get to the bottom of it right now. You had a testable patch on last week.
Yes, ma'am.
Well, you had a patch on. I don't know if it's testable or not. He's
I gave it to him to test, so yeah.
Did they take it off your arm,
Yes, ma'am.
or you handed it to them?
No, they said that, like, I feel it, and she gets the little tweezers, and she take it right.
That happened last Thursday.
Yes, ma'am. I owe Johnny some money on my previous patch.
What?
I owe Johnny some money.
Okay, but that's not what they're saying. So I need to find out why they're saying specifically with regard to you that you went in without a patch on.
Buckle up, guys. Today we are stepping inside a courtroom where something clearly isn't adding up. From the very first seconds, the judge's tone already carries frustration, and that's not something you hear in a routine hearing. This sounds like someone who has dealt with the same issue multiple times before. The focus immediately shifts to a man whose compliance is being questioned again. You can sense this is not his first warning, and the judge isn't in the mood for repeated excuses. The way she addresses him shows authority mixed with impatience. It's almost like she already expects a problem before he even speaks. That alone builds tension right away. When a judge starts like this, it usually means the situation is serious. And from an outside perspective, you can already tell this moment is going to unfold into something bigger.
Did you check with probation?
Probation doesn't have anything to do
Well,
with
if
it.
you get drug testing in court.
I'm tired of doing that. That's what I've done every time we've been here. I'm not going to keep doing that. We're going to either have patches that work or he keeps on or not. I just got to see why they sent this email. All right, we got to get our jury seated. So here's what I'm going to do. I'm going to let Anna work on figuring this out with talking to Johnny's and Al Reed. I'm going to have you guys back here. Plan on being back this coming Monday. I'm going to reset it to Monday. If it gets worked out and I don't need y'all here, we'll send you a new reset for a different day. But plan on being back in 1 week, and that way, if something happens, we'll figure it out. But we're going to talk to Johnny's. We're going to talk to Al Reed.
I could just wait, wait.
I got to get a jury seated.
All right.
We're already at 2:00, and I've had a jury waiting for an hour. So,
Johnny's, the bondsman said they've been putting it on him since August 25th. I have
Okay.
talked to Johnny.
Call Johnny's.
Wait on that.
That's all right.
Here's where things start to heat up in a very real way. The judge introduces an official email from the testing facility, and this changes everything instantly. According to that report, the defendant showed up without a proper, testable drug patch. That's not a minor mistake, it's a direct violation of court conditions. But instead of agreeing or explaining calmly, he immediately denies it. Now we're looking at two completely conflicting versions of events. One is documented evidence, and the other is his personal claim. From a third-person perspective, this is where doubt begins to form. In a courtroom, written reports usually carry serious weight. The judge is now comparing facts against words. And the more he denies it, the more the tension builds, because someone here is clearly not telling the full truth.
All right, y'all can go. We'll send you a reset. It was last week. I said 9:20. Good morning. You're Benita Graham? And Ms. Graham, did you get a lawyer hired?
No, ma'am. I did visit 3 times.
Who'd you talk to?
I talked to Kendall, Ms. Holmes, and Attorney Adams. And
Okay.
he did state, Attorney Adams did state if he was elected that he would represent me pro bono.
Okay. So, well, what do you mean if he was elected? I don't.
Well, if you assigned him to my case.
Oh, yeah, does it work like that?
Okay.
Okay. So are you working?
No, ma'am.
Okay. Why aren't you working?
I'm retired and I only have one source of income, and that's Social Security for my husband's death.
Okay. All right. So,
And I do have cancer.
okay. So what I'm going to do this morning, Ms. Graham, is have you fill out some paperwork. Thank you for doing what I asked you to do. To see if I'm going to have you fill this paperwork out to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely. Don't leave it all blank or put zeros. And then I'll take a look at it when you're finished. If you'll step over in front of the clerk, she'll give you that information.
Yeah, actually, about the monitoring situation, if I can be relieved from that.
Let's take care of this first,
Yes,
okay?
ma'am.
Good morning, Anna.
Okay.
At this point, the judge tightens control of the conversation. She starts asking very direct, focused questions that require simple answers, yes or no. There's no room left for long explanations or confusion. But instead of giving clear answers, the defendant struggles and hesitates. His responses feel uncertain, and that hesitation stands out immediately. From an observer's point of view, this is where credibility starts to weaken. When someone can't answer directly under pressure, it raises serious doubts. The judge picks up on this instantly and pushes further. The tone shifts from general questioning to something more intense, almost like a controlled interrogation. Now, it's not just about whether he had the patch, it's about whether he's being honest at all. And that shift makes this moment much more critical.
Joan Kraus. Good morning. Are you Joan Kraus?
Yes, ma'am.
And Ms. Kraus, this is your initial appearance in cause number 25, DCCR 0904. You're charged with a third-degree felony offense of driving while intoxicated, third or more, from July 16th of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, I got a court appointment.
Right. So when you're in custody, we automatically give you a court-appointed lawyer. If you make bond, I expect you to at least try to hire your own lawyer. Are you working?
No, ma'am.
Okay. Why aren't you working?
Retired.
Okay. And so you have a
Now the situation begins to crack under pressure. The defendant starts sharing details that don't fully align with what he said earlier. He talks about the patch being removed and then mentions owing money to the testing center. These may seem like small details individually, but together they create inconsistency. From the outside, it feels like his story is shifting as he tries to explain himself. And that's exactly what raises concern in a courtroom. Judges don't just listen to what is said, they pay attention to how it changes. This moment quietly turns the situation from confusion into suspicion. The more details he adds, the less stable his version sounds. And now, it's becoming harder for him to maintain a clear, believable narrative.
retirement income.
Yes, ma'am.
So what I'm going to do, Ms. Krause, is reset your case to give you some time to try to hire a lawyer. Okay, you need to, if you get someone hired, bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options.
Okay.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand?
I do, ma'am.
And are you, do you have the ignition interlock device on your vehicle?
No, ma'am, I don't have one.
You're not driving. I want to make sure you understand it's a condition of your bond. You cannot drive unless you have that on your any vehicle. Do you understand?
Yes, ma'am.
Okay, step in front of the clerk. She'll give you your reset notice.
Fine.
Sarah Henderson. Good morning. You're Sarah Henderson?
Good morning, yes, ma'am.
And Ms. Henderson, did you get someone hired?
No, ma'am. I got 3 people, but my income might change. Because I'm trying to see if I can maybe qualify to.
Who'd you talk to?
I talked to Langston, Scott Adams, CL Swisher, and Keith French.
Mm-hmm. Okay. And what do you mean your income has changed?
Well, I switched jobs and I'm making a little less. You know, but at first I was making too much to get one the last time I was here.
Mm-hmm.
But I'm trying to see if maybe I qualify to get a court-appointed lawyer now.
Why did you switch jobs to make less money?
Well, I didn't really have a choice, you know, so
Okay.
I didn't want to switch.
Where are you working?
The city of Ohio,
Okay.
streets and drainage.
Okay. So I'll let you go ahead and fill out that paperwork again. Make sure you fill it out accurately and completely, just like you did last time, and then I'll take a look at it. Okay? Step in front of the clerk. Janisha Jackson.
Doesn't apply in this case, you don't just leave it blank.
Instead of making a quick decision, the judge chooses a more controlled approach. She pauses the situation entirely and decides to verify everything directly with both testing sources involved. This shows a strong sense of fairness and discipline. Rather than relying on assumptions or incomplete information, she wants confirmed facts. The case is reset, giving time for proper investigation. But interestingly, this doesn't reduce the tension, it increases it. Because now there's an expectation that the truth will come out soon. And when it does, it could have serious consequences. From an outside perspective, this is a powerful moment. It shows how the legal system prioritizes evidence over emotion or argument. The pause isn't a break, it's preparation for a more decisive outcome.
Good morning. Are you Janisha Jackson?
Janisha.
And Ms. Jackson, this is your initial appearance in cause number 25, DCCR 0903. You're charged with the second-degree felony offense of abandoning or endangering a child, and that's from May 26th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am, not yet.
Okay, so what I'm going to do, since you've made bond, is I'm going to give you about a 30-day reset to give you some time to try to hire a lawyer.
Okay.
If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer. They'll tell you what to do.
Yes, ma'am.
If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand?
Yes.
All right, step in front of the clerk. She'll give you your reset notice. Presley Viltz. Good morning, you're Presley Viltz. And Mr. Viltz, did you get someone hired? Who'd you talk to?
Scott, King,
Speak up, please.
Scott,
I can't hear a word you're saying.
Kimberly,
James,
James who?
Nathan.
Okay. So where are you on being able to get one of them hired?
I just started picking back up the work.
Okay, where do you work? Say?
Court.
Okay. So what I'm going to do, thank you for visiting with those attorneys. I'm going to give you one more reset.
As the courtroom moves forward, we start seeing a wider picture of how these hearings operate. A new defendant steps in, facing financial struggles and even serious health issues. The tone shifts slightly, becoming more measured, but the judge remains firm. She explains the process of applying for a court-appointed lawyer, making it clear that support is available, but only through proper procedure. This moment highlights an important balance. The court can show understanding, but it still expects responsibility. From a third-person view, this shows that the system isn't just strict, it's structured. Even in difficult personal situations, there are rules that must be followed. And the judge makes sure those expectations are clearly understood.
See if you can get some funds together to hire one of them or anyone else. If you get them hired, bring that reset notice. If it's not going to work out with one of them, talk to 3 others, bring me those names, and we'll discuss your options if we're still unable to hire someone. Okay, so make sure you talk to 3 others if you don't get somebody hired. All right, step in front of the clerk. Crystal Latulas. Good morning, ma'am. You're Crystal Latulas. And Ms. Latulas, this is your initial appearance in clause numbers 25 DCCR 0850 and 0851. In each of those cases, you are charged, give me a second, with the second-degree felony offense of abandoning or endangering a child, and that's from May 30th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
This is the thing that you was, I'm gonna be honest with you. My child, when I got out, I had no stipulation.
Speak up, please.
When I got out, I had no stipulation, right? So the week that I got out, I got a call that she said that the child had to be removed from the home. I'm a parent at the end of the day. I have a nursing license interfering with this charge that I have now. That was my whole point of starting over. I already had got my nursing license, but I want.
Okay, you're telling me way too much information.
Okay.
Here's the thing.
I was just asking about my child. Is there any type of way that I could get?
You need to get a lawyer, and they can file a motion asking, but just with your word, based on what you're charged with, no, I'm not going to allow that at this point, okay? So I'm going to expect you to try to hire a lawyer, reset your case about 30 days to give you some time to do that. If you get someone hired before the...
Here, the stakes are laid out very clearly, leaving no room for misunderstanding. Another defendant is warned directly about failing to follow court instructions. The judge explains that ignoring these requirements can lead to serious consequences, including increased bond or even jail time. The tone here is firm and intentional, not emotional. It's meant to send a clear message. From an observer's perspective, this is where the seriousness of the system becomes undeniable. Every instruction matters, and every delay has consequences. The judge isn't just giving advice, she's setting boundaries. And crossing those boundaries can change everything for the person standing there.
The next court date, bring the reset notice that you get today to that lawyer, and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me back the names of the lawyers you talk to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail.
Okay.
Do you understand?
I don't, he told me something about diversion from, we just stepped out.
Okay,
Diversion plan.
that's why you need to go hire a lawyer, okay?
Yes, ma'am.
Step in front of the clerk.
Sign mine.
Lisa White. Good morning. Are you Lisa White? And Ms. White, this is your initial appearance in cause number 25 DCCR 0923. You're charged with a second-degree felony offense of aggravated assault with a deadly weapon, and that's from May 24th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yes, ma'am. I talked with Mr. Alvin Samuel,
Uh-huh.
and he suggested the price, and that's really what.
Okay, perfect. So what I'm going to do, Ms. White, is reset your case about 30 days to give you some time to try to either get Mr. Samuel hired or anyone else. If you do get him or someone else hired before the next court date, just bring that reset notice to them. They'll tell you what to do. If you're unable to hire someone and if it's not going to work out with him, then I'm ordering you to visit with at least 3 other.
As more defendants come forward, a clear pattern begins to form. Many of them haven't hired lawyers yet, and most provide similar reasons like financial difficulty or lack of time. But the judge doesn't allow repetition to weaken the process. She gives the same instructions each time, firmly and consistently. From the outside, this feels like more than routine. It feels like a test of effort and responsibility. The court is watching who takes action and who doesn't. Each repeated warning adds more pressure. It's no longer just about understanding the rules. It's about proving that you're trying to follow them. And that distinction becomes very important here.
Other attorneys and bring me those names so I know you're trying, okay? All right, step in front of the clerk. She'll give you your reset notice. Yeah.
Sign my yes, and I told him he was through, so if you want to go ahead, and he hasn't yet.
He has it. If you'll call the name Christian Ainsworth, please. Christian Ainsworth.
Christian Ainsworth. It's okay. Where you go? Thank you.
No response, Your Honor?
All right, I'm going to forfeit his bond for non-appearance. He did call and say he had COVID. If he provides documentation of that, I will recall that bond forfeiture. Donnell Coleman. Good morning. Are you Donnell Coleman? And Ms. Coleman, were you able to get someone hired?
No,
Did you talk to some lawyers?
yes, ma'am.
Who'd you talk to?
I still have Mr. Ross.
I'm sorry?
Mr. Ross.
Uh-huh.
Mr. Ross.
Yeah?
Yes, ma'am.
What about him?
He gave me a deal, like he shot me a deal because based off of my income, he seems to change
Uh-huh.
because my case is still on that.
Okay. Did you talk to some other attorneys, or you were planning on trying to hire him? So what I'm going to do, Ms. Coleman, is have you fill out some paperwork this morning to see if you qualify.
This segment introduces a noticeable emotional shift. A defendant begins to explain personal struggles, including issues involving family and career setbacks. The story feels real and human, something many people could relate to. But the judge quickly redirects the focus back to legal procedure. It may seem strict, even harsh, but it reflects how the courtroom operates. Emotions don't guide decisions, rules do. From a third-person perspective, this creates a strong contrast. On one side, there's personal hardship. On the other, there's a system that demands structure and compliance. That clash is what makes this moment powerful and tense at the same time.
For a court-appointed lawyer. You need to fill it out accurately and completely. Don't leave it all blank or write zeros. Put all any income you have, any bills you have, and then I'll take a look at it. Step in front of the clerk. She'll give you that information. Jeremiah Paia. Good morning. How do you say your last name? Paye. I feel like we've done that before. Mr. Paye, sorry. Did you get someone hired?
I'm still in contact with Mr. Jeff Casey.
Uh-huh.
And I still want to get him hired, so I got a second job in order to do that. You asked me to bring a check stub.
Okay. And where's he from?
I'm not 100% sure, but he's with Jeremy and Jones, that law firm.
Okay.
This is my check stub from FedEx, and I started my new job this week.
Okay. You get paid every week or every 2 weeks?
Every week.
Okay.
But the hours vary from about 20 to 30.
And where's your new job?
It's in the mall in Port Arthur.
Okay.
Pivot.
Okay. So I'll give you a little more time. I mean, you're trying and that's great, or I can have you fill out some paperwork to see if you qualify. You want to try that today? Okay. Step in front of the clerk and she'll give you that paperwork. Make sure you fill it out accurately and completely, okay? Kayla Provost. Good morning. Are you Kayla Provost?
Yes.
And Ms. Provost, this is your initial appearance in cause number 25 DCCR 0972. You're charged with the third-degree felony offense of
In the final stretch, the pace of the courtroom increases, but the seriousness remains constant. A defendant who fails to appear faces immediate bond forfeiture, showing how quickly consequences can be enforced. There's no delay, no negotiation. Then the focus shifts back to the broader issue of drug monitoring and compliance. The explanation connects everything we've seen so far. Missing or damaged patches are treated as serious violations because they disrupt the system of accountability. From an outside perspective, this brings the entire situation full circle. It reinforces the idea that in court, consistency and evidence matter above everything else. And when those don't align, the system responds firmly. If you found this breakdown insightful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.